Welcome to Courtroom Advocacy for Beginners. Your presenter is Hugh Selby. Your opening statement must draw and hold your audience's attention. It is your case story, told in a non-argumentative but interesting way. It draws upon your case analysis. Its telling should reflect the decisions you've made about prioritisation of witnesses and topics. Because you're making a promise to the audiences. They will remember that promise, as will your opponent. You and your witnesses are taking the audiences on a journey, and you are promising them that it will be worth their while. Be short, be graphic, be clear, as you now make opening statements for both sides. Why both sides? Because, as we mentioned earlier, you must be able to understand both sides of the case. If possible, record your voice so that you can then listen as an expectant audience might to what you've had to say. If your decision-making audience is a jury, then find a succinct, enticing way during your opening to tell them how to join the facts to the legal elements. You must set out in simple, short language what those elements are. If you don't do that, then their treatment of your carefully ordered facts is bound to be haphazard. Judges usually explain the law at the end of the case. Hence, unless you give the jurors guidance in your opening, they will be assessing all the evidence, as they hear and see it, exclusively through personal whims. That's dangerous. For example, suggest to them that they should filter or sieve the facts through the elements. Alternatively, that the elements give them a tool that makes some facts sharper than others. Your closing argument reminds the audiences of decisions that they should have made along the way. As a result of your winning approach to examining and cross-examining witnesses, along with the promise and legal explanation you made in your opening, the audiences should have been reaching your desired conclusions on their own. Hence, the closing tells them how clever they are to have taken the facts and fitted them to the elements, explains any weaknesses, and parries attacks already made or expected to be made by your opponent. It reminds the audiences of the results of their cleverness and has them give you the verdict you want. That is serving their hearts and minds, or their wants and needs, whichever phrase is stronger for you. Now, try a closing for each side in the Jack and Jill assault case, making sure to talk with the audience, not at them. Once again, record it, listen to it. Note that if you're not brief, you'll lose them. But what do you do in closing when things haven't gone according to plan? When your side is heading towards certain defeat? First, remember the ethical principle that is the foundation of good advocacy. Then be sure to give your client a closing for which they will be grateful. Start and finish with the best points you can find among the wreckage. Defeated your client may be, but hangdog never. Your first task with any witness is to establish for them and the other audiences your relationship with them. With your witness, the nature of the team approach should be apparent as early as possible. This is achieved by how you settle them into role, how you introduce them, your choice of background questions, towards whom in the courtroom the witness and you are both looking, and by your taking care that both of you can be clearly heard by the decision makers. You manage your witnesses and their story development by covert, smooth control.
What is your name? Alex Selby.
What is your address?
Canberra, Australia.
What do you do?
I'm a media student.
When questioning your own witness, you are managing the flow of the story that they have within them and that you want to reveal as visual images to the decision makers. Just as traditional stories have chapters or episodes, so your trial story can be broken up into topics. The earlier discussion of case analysis described how the order in which witnesses are called and the order of topics that you treat with each witness should follow the guideline of strong start, strong finish, with weaker material in between. Now this means that the story is often told in a way that breaks with the time sequence. Capturing and keeping audience interest is more important than dogged adherence to this, then that, and then this, and so on. A chronological telling of the story is not necessary, providing that you tell the audiences that the chronology will be clear enough to them by the time you and the witness are finished.
We're going to talk about what you saw and heard. Our topics will cover, firstly, your point of view, the going up the hill, the top, and finally the coming down the hill. But just for your interest, we will change around the order in which we'll take them. The first being coming down the hill, secondly going up the hill, and finally what you saw at the top. Where were you?
I was riding my bicycle on a bike path near a hill.
While you were riding your bicycle, if you were doing so from your witness box, and you imagined a clock with 12 being straight ahead of you, was the hill before or after 12?
It was before. I think it was about 10 o'clock.
The distance between yourself and the hill, if you were to compare that distance to anywhere in the court, what would be involved?
It would be about the distance from me to you, but probably double that, so almost near the audience box.
Whether it's questioning your own witness or an opponent's witness, it is essential with any topic to ask sufficient questions to establish a foundation of relevance and to move the questions and answers forward in an incremental, preferably visual way. Any leap leaves a hole that's an opportunity for your opponent. They may make an objection, which we talk about later. They may exploit that hole when questioning that witness in cross-examination, and they can make use again of the hole in their closing argument against your interest.
Where were you?
I was riding my bicycle next to a hill on a bike path.
So while you were riding your bicycle, if you were currently in the witness box, on a clock face with 12 being directly ahead of you, was the hill before or after 12?
It was before, probably 10.
Because we want the decision makers to see the images that we create with the witnesses, we must establish a physical point of view, POV, that is the same for the witness, for us, and for the decision makers. Every person in a cinema audience watches the action from the same POV. The film director dictates that POV. As an advocate, you too must set out the baseline from which you, the witness, and the decision makers will see the action unfold. Setting the scene with a diagram, a map, a photo, or a video clip helps the audiences to understand the witness story. Such a visual also helps to prevent misunderstanding about point of view, about distances, about obstacles. But the visual must be introduced in the right way, so follow the necessary admissibility rules. And once it's in evidence, it must be used the right way. Questions that encourage explanation are termed open. They include each and all of the who, why, who, with, when, where, what and how questions. By contrast, questions that encourage a yes or a no or don't know, recall or remember are called closed questions. Both open and closed types of questions can be used in questioning your own and your opponent's witnesses. The skill is knowing when to use each type. The form of the question, whether it's open or closed, will do one of encourage explanation, require a one or two word response, or provide the opportunity for each of those. A question that begins with a D word, such as did, do, or does, should be avoided because it falls into that last group, that is, gives an opportunity for explanation or no explanation. Such a question fails the test of is the advocate exerting appropriate control. Note too that a question that begins with could you, would you, will you, can you, logically requires a yes or a no. However, the questioner usually intends an explanation. To avoid the confusion, do not begin courtroom questions with these coulds, woulds, will and can. Jack, as agreed, I'm going to ask you first of all some questions that the defence agrees with. Now, both you and Jill were working at a fun park, weren't you?
That's right.
And the usual way in which you and Jill brought pails of water down the hill was that each of you took one end of a stick that went through the pail's handle.
That's correct.
Now, on this particular morning, the morning of the incident, you and she had an argument.
That's right.
As a result of that, you weren't talking to each other.
That's, yeah, correct.
And on this particular day, you filled the pail at the well, didn't you?
I did.
Without her help.
That's right.
And it was when trying to come down the hill by yourself that you fell.
Yeah.
And you broke your crown when you fell.
That's right.
Let's now go to those facts where the two sides disagree. Let's start off, first of all, with the kind of hill that you worked on in this fun park. Would you describe this hill as very gentle, moderately steep, quite steep?
I'd say it was a pretty steep hill.
In terms of the length of this pretty steep hill, looking, for example, at the lengths of tennis court, how many tennis court lengths would you say was the uphill climb on this hill?
It was about 1.5, the length of 1.5 tennis courts.
Now, tell us again, what was the weather like as you went up that steep hill that morning?
It was raining.
And what, if anything, did the rain do to the ground on which you were walking?
It was very mushy and slippery.
Now, having told us that it was mushy and slippery, when you were about to go down the hill with the pail of water, what can you tell us about how near Jill was to you?
She was right behind me.
How do you know that she was right behind you?
Because when grass is mushy, you can hear people walking behind you squelching.
Now, finally, that staff that was usually used by both of you to carry the pail down, compared to your height, was the staff about the same, shorter or longer?
About the same.